if you're involved in a trust in the state of Florida and you suspect something is wrong, I'm going to give you the steps that you need to take before things kind of spiral out of control and to kind of help you understand what kind of questions you need to be asking before you decide whether you're in a real dispute here or not. Here's the bottom line. The first thing you need to do is communicate. Talk to the trustee, talk to beneficiaries, collect information, make sure you get a real firm issue of the facts. Disputes can sometimes arise over just uncertainty or miscommunication. And one of the things that all parties need to do at the front end, frankly, before you get lawyers involved, is communicate. Email if you can't talk on the phone, talk on the phone, gather the documents. But particularly when we're talking about, larger estates and real issues, information has got to be clear and distinct and black and white at the front end. Sometimes what happens is, accountings are missing or investments are risky or not real clear, but you need to be clear with one another about what the issues are. You may have to request that information as a beneficiary. And one of the things about Florida law is you shouldn't have to request the information. The trustee should understand that they have a duty to provide you the notice of the trust and all the investments and all the expenses on a regular basis. And they don't do so, that's a violation of the law, because Florida law gives beneficiaries the right to full accounting of all trust assets, income, and expenses. And if the trustee refuses or hesitates in the least bit, that's one big red flag that you need to jump in and act really quickly. You need to act quickly before the problem escalates, because it just becomes a lot more complicated the more the time plays on. If you think about trying to put Humpty Dumpty back together again and figure out money and accounting when years have gone on instead of just months, you understand how important that is. If we have to file something quickly, we want to make sure that we get good information at the front end. If we're talking about filing an action to remove the trustee, we need to be real clear about what those facts are that would support removing the trustee. The court can remove a trustee for mismanagement of assets, failing to follow the terms, acting in bad faith, just not communicating well. It's a serious thing because oftentimes that conflicts with what the testator or what the beneficiaries wanted. But at the end of the day, that's something that can happen and can happen really quickly.